for higher juicy news. Mema Obibia Akwaba. I had the latest hot kwa Aremeyaw Bravo. And until so you subscribe to channel idea, but more say over subscribe. Double and say over click the subscribe button. You know. Now wa barely notification. We understand video for free be upload. No. When the first person I want sa ebeka sa video. After we are now like video, give us a thumbs up. Now share my wo for so now when you be here now and somewhere ekoso ewo Ghana be mo. I think tentemara yebura ye and somewhere abeto ye so. With the breaking news and amede bremo national security which say wanna intercept 12 containers are $8 as taffy inside it. That's boxes more to say any gold bars, any counterfeit notes to say enye asem kitwa. Now yen share story GH1 TV one report here. So soon UTV so a report with the details ningina Abraham any video just say national security for one bura hodo money one who ningina ababetuja. Now yen share story no way GH1 and one the abetuja one to say national security seizes US dollars, gold bars and counterfeit currency in a warehouse raid at Sapema in the Ga West municipality. Not just say baby a fro horse Sapema a Ga West municipality, which is one called raid. What me say when you tip off NHS one bura or many ya containers in more just say dollars ya staffy any good basa just say containers in the ningina ashishi more just say ababeto abonting. Na ya share UT4 at the reporting by one day ebetuja ya show mudi nafi yɛnhwɛ video national security for the bura how the course nyina mede ne nyina ebramo yɛnhwɛ UTV4 one story no yɛnhwɛ UTV wanna say kind story now say national security has seized an unspecified amount of US dollars and Ghana cedi including counterfeit notes hidden in 12 20-foot shipping containers. Let's just say they share 12 20-foot shipping containers and one this ACK dollars any counterfeit notes any gold bars one day ashim. Now say the containers were traced to a warehouse in Sapema Ga South municipality where officers found bundles of dollars concealed in a wooden boxes filled with cement. Necessary there are boxes and I bundles in guma cement in there I just say cover home. I say more cash were hidden behind plywood barriers and sealed with charcoal. As a plywood, no one there shishimo, they just say bidie near there a serious said about I say 2 containers are still missing, but security trackers are in pursuit. A manhunt is underway for 4 suspects, including a ringleader known as Alhaji. Just say penny only di anymore one decide money in Anno. Or only a friend Alhaji just say you go so everyone the din and yeah as them get to say. Authorities also discovered suspected gold bars, counterfeit cedi notes in 50 and 100 denominations, and fake Ghana Army uniform and boots. Not just say soldier for Paboa ne one boot in the beginning. It's a fake one uniform one fake one one who in any a year Ghana cedi 50 denomination 100 cedi denomination one who a counterfeit say and yet the correct cedi. Now share a video a betu dwa national security for one bura or the course war holding share a video no a GH1 credit to GH1 one day a story a betu a report na a course on
amount of US dollars and Ghana cedis including other counterfeits hidden in 12 20-footer shipping containers. The containers were tracked to a warehouse at Sapema in the Ga West municipality where a special operation was conducted after a tip-off. The cleverly concealed currencies, mostly bundles of US dollars, was found in wooden boxes filled with cement. Other boxes opened in the warehouse during the operation revealed extra currencies stashed in boxes that are barricaded with plywood and concealed with charcoal. According to the national security operatives involved in the operation, 2 containers are still on the loose, but state security trackers are hot on their trail. Meanwhile, a manhunt is underway for 4 suspects, including a ringleader known only as Alhaji. The warehouse yielded even more shocking discoveries, including boxes of metals suspected to be gold bars, counterfeit notes in 50 and 100 cedis denominations, and fake Ghana Army uniforms and boots.
Yo, it for winning a year reporter about to national security, and I just say one could ready be a friend or supplement. I just say near one who containers in Anuna Medini in a Bremo. Afi Yanko a year and some for minty a year report here about to minty.
The cases against the Democracy Hub protesters, we have a copy of that we'll put on the screen shortly. The Attorney General discontinued the case against the convener of the Democracy Hub protesters who were arrested for demonstrating against illegal mining, and then also he withdrew the charges against Collins Dauda and 4 others in the Saglemi housing project case, which has been running for quite a while. Collins Dauda and 4 others, $200 million, this Saglemi housing project trial. A nollie prosecutor notice was filed at the High Court Financial Division 1 in Accra, confirming that the state will no longer pursue the case against Alhaji Collins Dauda, former Minister for Works and Housing, Kweku Annan, and Alhaji Ziblim Yakubu, Novitete Angelo, and also Andrew Cloconas. The notice signed by the Attorney General, which we have a copy of, was filed in February, that's a couple of days ago, in fact, bringing an end to the prosecution's case against the accused. And that's what you see on the screen there. About 53 persons were arrested in this matter of the Democracy Hub protesters. In fact, they are not alone in this. The AG also withdrew the charges against the former Senate boss, Dr. Ernest Thompson, and also 3 others as well. And we have a copy of that also we'll put on the screen. But these are the high-profile cases that the AG has discontinued so far, with some Republic versus Samuel Oswan-Pofu and 1 other on the leak tape inciting violence against the Electoral Commission, Republic versus Ato Forson, and 2 others in the ambulance purchase deal, and then also what we saw yesterday as well as the now governor of the central bank. That case as well was discontinued last week. Matibebo, you're indicating that even though the AG has the right to do so, you expected some more detail in the reasoning behind the discontinuation. Why is that? Why is that?
Yes, so that it will be clear to us the basis on which the decisions were taken. You see, we've been saying it every day, and it's good we keep repeating, because repetition is just like the Bible. We've been reading the Bible or the Quran from infancy, and we still keep reading, and we get better insights each time we read. So repeating too helps. We refine the arguments each time we repeat. Now, the thing is that, you know, just say I've stopped this case. It's opaque. At least analyze for us. Oh, maybe X, Y, Z are the reasons for stopping the case. Then we can scrutinize the reasons. Do they hold master? So that in the event that the reasons assigned don't hold master, it means that, go back. So let me give you a typical example. Even though, so the typical example I'm giving also reinforces the point that for certain cases, the moment the Attorney General withdraws the case, the reasons are even obvious. Look at Ato Forson's case. We're all here. The tape was Jakpa, the conversation between Jakpa and Godfrey Dami, right, was recorded. It's not a matter of evidence. It was admitted in court. You see in it that Godfrey Dami says Ofori Atta and Akufo Addo are on his neck to get Ato Forson convicted at all costs. And then you see, also you hear Godfrey Dami coaching Jakpa to go and procure a fake medical excuse duty. Then also coaching Jakpa to go and bear false witness in court. You see, perjury, etc. So when such a case is stopped, it's obvious that that case had embarrassed us so much that it showed that here is an Attorney General with the president who were using the judicial process for their own political ends, right? Okay. So that one is obvious. Even if he didn't give an explanation, we all can live with it. But at least it's still better to say that, look, the tape is there. This is what the tape says. In law, we don't use criminal prosecutions for political ends. It's not for political vendetta. It is not to retaliate or avenge any thing that somebody, a politician thinks has been done against him, right? So advance all the reasons, then we can look. If we think yes, that is it. If we don't think so, you know, the debate can go on and on and on, and then the Attorney General may see that, oh, is that so? Then maybe we'll rescind the decision. We'll go back. Yes.
I see.
Yes. Or if the Attorney General decides not to do it, well, you know, Ghanaians are also watching, just like what happened in the previous administration, when Akufo Addo would then listen. When the, you know, when I say mampam, you say I shouldn't say mampam, so I'll not say mampam,
yes,
right, etc. You saw eventually what we did in the elections. You saw what we did. You see, today, ADG is sitting here, head of NPA. Before then, it was one lie. I want to rescue this country. Mustafa Hamid, good morning. The rescue. Maybe you should come here.
Oh,
it's very important.
Yes.
So
we
are saying that the assigning reasons helps our democracy, so that before an Attorney General takes the decision to cancel a case, to stop a prosecution, he will think through it carefully. And, you know, yes, it helps. You see, they say sunshine is the best form of disinfectant. It helps. Look, and I see this disclosure of the reasons. It's just like the way for decades now we've been on the road towards what? Disclosure of assets that are declared. Is that not so?
Right.
Yes, I see. So we are looking for greater transparency, greater accountability. And you heard what Bobby said earlier on, and I'll just repeat, because the Supreme Court has been repeating this principle in many of the constitutional cases, that the bedrock of our constitution is probity, accountability, transparency, etc. Right? Yes, so it's in the same direction. Assigning reasons helps our democracy, just like publication of assets that public officers have declared.
Right. On this matter, so the demand is, yes, the AG...
Mr. Can I give one, just 30 seconds? Let me give an example. So you see Gregory Afoku's case. We all could see that the state had lost the case and became clear to them. But because they don't have to assign reasons when the such things happen, they just discontinued the case. Then went and started afresh. It went, judgment came, they couldn't convict Afoku. You see the abuse, and now they are preparing to do a third trial. You see, so let's assign reasons. When we do that, I'm sure it would help. And by the way, we repeat the call that Afoku should be granted bail. Let's grant Gregory Afoku bail. Akufo Addo has punished him way too much. Punish him because of his brother Paul Afoku. We shouldn't use executive, you know, power for personal vendetta. Because Akufo Addo had a beef with Paul Afoku, then it's like his brother should not be admitted to bail. 8 years. Why?
Let's see how the AG and the Justice Delivery will deal with this matter of your call and your appeal as well. It is in the interest, according to Lawyer Martin Pebo, of sunshine and some level of transparency, that he wants details of the reasoning behind the discontinuation to be made public for all of us. Is that one that you agree with?
Okay, so you say, first of all, the power of the Attorney General flowing from Section 54 and the power to file or enter a nolle prosequi 54, the power of withdrawal 59 of Act 30, and more importantly, the constitutional provision under Article 88 empowering the Attorney General first to initiate criminal prosecution has always been a public duty. Now, prosecution is a policy tool. And usually for policy tool, you want to, as it were, give the one having the policy a bit more flexibility so that the Attorney General of the Republic can take a policy decision that, look, yes, it's true that maybe there be evidence that so and so person might have committed a crime. But for the interest of all of us, we will end it. And I recall vividly in the UK, there was this incident involving arms sale to Saudi Arabia. Either the Czech courts or one of them inquiry. The evidence came, and there were real matters of wrongdoing that ought to have been prosecuted. the Attorney General of the United Kingdom, okay?
Right.
The Attorney General of the United Kingdom took a policy decision that, look, if I go into this prosecution, maybe the Queen herself or persons associated with the Queen may get involved.
Yes.
And for that matter, we are bringing closure to that.
Yes.
It's a power reserved to the Attorney General. And that power even flowed from the fact that at that time, it was the King who decides who gets prosecuted.
Right.
And for that matter, you needed to give the King a certain laxity in terms of taking said decision. So if you look, the case you reference, my Lord Justice Mafosaw's decision, may he so rest in peace, in the Afoko versus Attorney General decision, if you look at that decision,
Yes.
Afoko never challenged the constitutionality of the Attorney General's knowledge prosecutorial power.
Yeah.
However, gave an indication that the exercise of that power should conform with the dictates of Article 296, particularly C, the requirement of fairness. Because that can also be subject to abuse.
Absolutely.
In the sense that you have a situation where in the Afoko matter, the prosecution had closed its case. The judge was just willing to give further directions because it was a trial by indictment.
Yes.
Just then, the Attorney General says, we are filing a null and felt it was unfair to him.
Yeah.
Right.
Having gone through all those.
this
But the courts in its wisdom said, no. The Attorney General, and look, if you look at 54, it says at any stage, at any stage, emphasis, the Attorney General reserved the power. As to whether reasons should be given for that exercise, I don't agree with the requirement of providing reason.
Why is that?
Because of the policy implication for prosecution. Prosecution is a policy tool. It's a tool for social engineering. It's a tool to do many things. If you have to assign reason for the exercise of that power, it may open up a Pandora box. And I think from a policy point of view, that disclosure is not material. But you see, the conversation had been raised relative to some of the cases. And I make particular reference to the Republic versus Dr. Johnson Esiama. Look, you, the journalist, should be doing a right of information request. Under Godfrey Dame as Attorney General, did he receive briefing from his own attorneys to discontinue the trial?
No, as far as we do know.
Good. That's what you should find out. So that if you, an Attorney General, your prosecutors are telling you that there is no evidential basis to continue with this prosecution, then we should know why you want to continue.
That's a CMS case, specific.
Yes.
Okay.
You understand? Was Godfrey Dame at any point briefed to stop the prosecution of Esiama? If so, why did he continue?
But somebody who asks Agodo.
But then
somebody who just asks Agodo.
And you see, these are very serious matters. Look, the prosecution of Esiama was completely unwarranted. Esiama was only prosecuted to shut him down.
Shut him down from what?
Good. If you recall, in the very early days of the Akufo Addo administration, they raised this issue of interoperability. Of the three governors, the governor, the two deputies, it was Esiama who did a press conference to defend that decision. Because at that time, Vice President Dr. Mahamadu Bawumia needed to criminalize the interoperability contract in order to award the contract to a different company. And so when Esiama did that press conference, Dr. Esiama did that press conference and said at the time, the decision by the Bank of Ghana to enter into that contract was based on sound judgment and the numbers. The government then decided to teach him a lesson. Look, painfully, if you look at the prosecution of Dr. Esiama, it was based on the memo. And if you look at the memo which was tendered, he had written on top of the memo, okay, approved, memo. Upon receipt of the technical report of the banking supervision, when they received the request from UT Bank, that was the basis on which he was being prosecuted. The decision was taken by the three governors at a governors meeting. But he was singled out for that prosecution. And there was no doubt whatsoever that the prosecution of Dr. Esiama was actually an instigation from the then Vice President's office.
Was it from the Vice President's office?
Yes, it was an instigation.
Dr.
And you see, let me say this. Never again in the history of this country should we subject a Ghanaian to this painful persecution simply because we possibly disagree with them politically. And you see, Alfred Okansi, prosecution is a very powerful tool.
Yes.
But the most dangerous thing that you can ever have is when a president decides to weaponize prosecution to deal with his political opponents. Once you get to the point where a president decides to weaponize prosecution for purely partisan political end, we lose the very essence of it as a public tool. And that is what happened in the specific case of Dr. Esiama. And that is why I have no doubt at all that even before the Attorney General filed this process, there were already memos and conversation within the Attorney General to discontinue the
So
prosecution.
in the case of Dr. Johnson Esiama, you are saying that if called upon, there's reference to memos
already
to the former Attorney General
to stop his trial.
To stop the trial of Dr. Johnson Esiama.
Absolutely.
And he had the prerogative to disregard those trial, the memos, I beg your pardon.
But you see, it should be,
which he did, and he decided to continue.
No, but the point is that there was no basis for continuing. You see, prosecution is based on law and evidence. So, for instance, if you make an accusation that I've caused financial loss because ABCD, but the decision was taken by three of us, why single me out? Three people meet at governors meeting, and a decision is taken at the level of board. And then you single me out for prosecution. There must be a reason why you do that. And I'm saying that it is because Dr. Johnson Esiama, by 2016, has taken the step to defend a decision taken by him and his other colleagues on the interoperability. The then Vice President had an interest in the interoperability conversation and therefore had to scapegoat him for criminal prosecution.
Well, we don't have.
But you see, let me also raise another important matter. Look at the prosecution of Dr. Opuni. And that is why when I hear some of my MPP friends make noise, I heard Gideon Boako on the prosecution of Dr. Esiama. I've heard my learned friend Bafwewa and co. Look, you guys have no idea what people had to tolerate in 8 years. Look, I have with me the judgment of the Supreme Court. When Opuni applied for the Seshurara,
Okay.
look, we should never do this to any other Ghanaian again. Never again. Look, the lives of Opuni, Seydou Agongo, we need to apologize to them.
For what exactly?
For the persecution. Look, Seydou Agongo has a bank, Heritage Bank.
Okay. He had.
Then the Bank of Ghana, led by his governor, issues a press statement and says, we are revoking your banking license. Why? Because you are facing criminal prosecution. Now, when you do an act in anticipation of an outcome, which outcome is not already out, you do everything to achieve that outcome.
Yeah.
And so the very moment the governor of Bank of Ghana, Dr. Addison and co., took the decision to revoke Heritage Bank's license on the basis that they were facing criminal prosecution, it was as good as having convicted them. Because then you needed an outcome on conviction to justify your proud decision. So that ultimately you now say, okay, you see, we said it too. We revoked the license based on A, B, C, D decision. And that's exactly what happened in the Opuni matter. So if you read the Supreme Court decision, that's the Republic versus High Court, Criminal Division 1, ex parte Dr. Stephen Kwabena Opuni, Attorney General as interested party. Read the reasoning of the majority, my Lord Justice Poaman, Justice Amadou Tanku, and Agnes Doji, when he applied for that certiorari, eventually it was overturned on a review. But that circumstance we'll discuss another day. You have a situation where a trial court, listen carefully, and we are all lawyers, three of us here are lawyers. In a criminal trial, the Attorney General brought a prosecution witness to court. Listen. Then defense attorney said, okay, we want to introduce ABCD evidence, 14 pieces of documentary evidence through the prosecution witness. The judge, adversarial, asked prosecution, do you have any objection to defense counsel tendering this document through your witness on record? Prosecution, no objection. Then the judge proceeded. On the basis of the no objection, I admit this document pursuant to Section 6 of the Evidence Act, among others. Now, defense attorneys clear in their mind that the existence of those pieces of evidence on record completely exculpate their client. They do a submission of no case. Now, guess what the judge does? The judge goes home. In writing his submission of no case, now decides to expunge those documents that he himself admitted without no objection. This is the kind of thing that people went through under Akufo Addo. How in God's name do you want an Attorney General whose soundness is based on fair trial to continue these kangaroo things? Because you see, the essence of a criminal trial is that the person will be offered the protections of the Constitution. If, when the documents were being tendered, the judge asked the prosecution and prosecution, we have an objection, defense will now have the benefit of responding to that objection. You don't offer them even that opportunity. Why you think those documents should be expunged? You go home and you do this. And listen, for the first time, 3 Supreme Court judges, and remember at the time our Lord Justice Onyenuga was doing this case, he was a Supreme Court judge. His own colleague, 3 of his own colleagues, Supreme Court judges, had the extraordinary courage to say that, my Lord, you went far. And not only that, this is a judge who, in a submission of no case, begins to make such pronouncement against accused person. Look, at page 54 of his ruling, this is what he said. All these were perpetrated to facilitate the second and third accused business and defraud Cocoa Board. If at the submission of no case, a judge makes this far-reaching assessment, it's as good as having convicted the people, even before you ask them to open their defense. Because
the explanation given by the central bank and even collapsing, or in fact withdrawing the licenses of Heritage Bank, was that the bank's capital, quote, appears to have come from sources which are suspicious. Appears to have, and I'm
remember that there is this famous decision, one of the commissions of inquiries, where the judges said a multitude of suspicion does not amount to what? Ali Kasina, the famous Ali Kasina decision. Multitude of suspicion. This is the Bank of Ghana taking and revoking the license duly given to a businessman on the basis of suspicion, or what they consider to be appearance. I mean, how in God's name can you govern a country on the basis of this? So if you look at all the cases that the Attorney General has taken that decision, either to withdraw or, as it were, file nolle prosequi in respect, they are actually to serve the ends of justice.
Okay.
It is so unfair what we have used the powers of the Attorney General to do. How in God's name can Godfred Yeboah-Dame, beyond ego, say he is going to appeal the decision in respect of the Honorable Kesel Ato Forson? Look, what former appointees of John Dramani Mahama from 2017 to 2024 were subjected to, I wonder, if Akufo Addo's appointees, if any of them is subjected to the same, if any of them can survive, we cannot organize a republic when what we do is either to serve the ego of the president, his vindictive mindset, among others. And that is why the hope I have in this republic is that at least we have a president like John Dramani Mahama, who has a fair sense of fairness. That, look, everybody, once the person is a Ghanaian and a citizen, must be given the benefit of due process. And not basically just parade people at a point when you just want the people to go through a certain hurried judgment. Look, how in God's name are we going to explain to our children and children the manner in which Justice Anno was hardly transferred to Kumasi simply because he said the Opuni trial ought to start de novo? How in God's name are we going to offer that explanation? Let's never get to the point where you begin to see a certain ambush by state actors against citizens of this republic. It is unfair, and that is why I want to commend the Attorney General for the swiftness. Because the state spends money in this prosecution, and what has been the outcome? Waste of public resources.
Let me bring in Labo Bansi here, and a good friend of mine, a PhD candidate at the London School of Economics, who is watching us right now, says prosecution is a political decision, really, and in his view, that is what describes a number of things that has happened. But the explanations given, even though the AG didn't give us the detail, it appears we have some sort of detail.
Yes.
To explain the decisions that have been made. But does it tick the box for you?
I was just prompting Senior Pebu that, well, he has his reasons now. Most of them he didn't ask. But I would want to focus on the larger picture. You know, Godwin, I think he represented some of them at some stages.
In fact,
yes. So he would have had the benefit of the facts that we do not have, or I do not have. Indeed. And so I'll not challenge him on the facts and the reasons. But you see, the beautiful thing is that in his submission, he has spoken passionately with the law.
Indeed.
And the facts that he knows. And from what he has said, one would have expected that, okay, from this trajectory, without the benefit of any contrary facts or opinion, that the end of the prosecution would have been a failure.
Okay.
From what he has said. So if that is the opinion of the Attorney General, why do I waste state resources to pursue it? But on a larger scale, assuming we are raising this now because the persons involved are politically exposed persons, or are deemed to be politically exposed persons. But they are private individuals who have suffered the use of this tool against them.
Indeed.
And I think that is the larger, beyond this, that we should look at. Why we should restrict the use of this withdrawal and nolle prosequi provided in the Constitution. The way it is now, Alfred, you can be prosecuted a day before the judgment will be given. If the AG decides to enter nolle prosequi, you spent maybe 4 years going through prosecution. A day before judgment will be delivered. If for whatever reason AG suspects that you will be freed, he can enter nolle prosequi. You know what that means? It means that when you are leaving the court, you can be rearrested and started all over again.
That focal case.
The withdrawal, depending on the stage it has reached, it has those consequences. If it is done before you close your, before the state closes its case, they can arrest you and start. But if it's after, then it becomes auto.
So in any of these cases discontinued, does it have that probability of maybe another regime, another AG feels like, you know what,
I think what was entered, I read somewhere withdrawals. And some of them, the withdrawals were at stages where the accused persons had opened their defense. So what it means is that the case is closed forever. I think there is 1 or 2 where the accused person had not opened their defense.
Collins Dowda, I don't think
they've opened their defense. So that means that matter can be revisited if it was withdrawal. If it is nolle prosequi, irrespective of the stage the case has reached, it can be revisited. But I think we may need, as part of our reforms, some form of requirement for the Attorney General to explain to the public.
Oh, you are.
Because it is public resources that is invested. So I didn't have to wait for Godwin to explain to me the basis. Because it is my taxpayers' money, as a Ghanaian, and state resources that have been used. So maybe it's a matter that Senior Martin Pebu can take up to the Supreme Court as part of his human rights campaign.
No, but already the Afoko decision, the Afoko decision, that was the main consideration. Because even the lawyers at the bar agreed that the constitutionality of the Attorney General's power to do is not in doubt. However, the fairness, the reasoning, pursuant to Article 296, and in the view of the court, nowhere, because of the unique powers of prosecution.
The court had to be more progressive.
I think that
the court was not being progressive.
No, I think that, you see, Martin, you have very wild views. And sometimes
the wildness is good for progress.
And sometimes your wildness requires certain restraint. You understand?
Now you're in government. You are beginning to walk back.
No.
You are beginning to walk back.
I share the same view with you. But I'm saying that the power to file a nolle prosequi, if it's subject to the question of reasoning, means that it is amenable to challenge.
Yes. And that's what one should be.
No, but you see, again, the Supreme Court panel that decided this question of whether or not it should accord with the dictates of Article 296C, where you need to offer some practical reason so that it can be challenged. We need to broadly look at it.
That is what I'm saying.
Because I remember when my senior Osafo Boabin moved the application on behalf of Afoko, one of the things that he raised is that put the Republic in a situation where it is very dominant against that of an accused person.
Right.
And the fact that you go through a full trial, you are paying lawyers, and last minute the Republic says...
That is exactly the point.
So you need to also evaluate all of
That's the point I'm trying to make, that if it is taken as a human rights question, it may have a... Because you see, the Constitution gives you compensation only if you are wrongly imprisoned. If you are wrongly imprisoned and it's found out that your imprisonment or incarceration was unlawful, you're entitled to compensation. But if you've been taken through 4 years of a trial and then it is withdrawn by means of nolle prosequi or any other means, the Constitution doesn't provide any means of compensation.
Absolutely.
So you would have spent, maybe these persons that face the trial can afford lawyers like Eduji, 4 years, 8 years, like you have said, they can pay. But if you have been wrongly accused of murder, for instance, and then you've gone through this, you've been able to get a lawyer who has done it, and then at the end, the state feels that they are going to lose the case, they withdraw. The Constitution doesn't provide you any compensation. They just write a letter, and that is it. You go home, your people will be happy, but all the time, all the embarrassment that you've gone through, there's no compensation. So I'm saying that it is not as if the nolle prosequi cannot be exercised, but there should be a regime where, for instance, it is at a certain stage, and the state indicates that they do not intend to resuscitate the matter, then the person who has suffered this undue prosecution or persecution should be entitled to some form of remedy. As a republic, I think we owe our citizens
in 30 seconds. Look, if you pick, for instance, the SNIT OBS one involving Ernest Thompson,
yes.
You have a situation where even the trial judge had reason to say that the first prosecution witness that the prosecution brought was lying through his teeth. In his ruling on the submission of no case, why would the Republic parade witnesses in court that the court can say that they were just brought in? In fact, the court described him as treacherous and dangerous, and that he only came to court to project a holier-than-thou attitude. These are all in the judgment. So how in the mind of a prosecutor, not a prosecutor, look at all this on record and say, let's continue with the trial? What end does it serve? So that the prosecution's own case, the weakness is inherent in the witnesses that they brought to court. I was involved in the Colin Dada Sagleme trial.
Okay.
Painfully, you have situation where prosecution witnesses who had nothing to do with the project are brought in, and you ask them, do you have any personal connection with the project? They say no. So on what basis are they in court as prosecution witnesses? So look, let's be fair to all. That is all that I say. That be fair to people.
Okay.
You may disagree with their politics, but be fair to them.
Yeah.
So
finally, let's get this. Can I go in? You see, you look at the Crown Prosecution Service, right? Now, they say that if you are going to terminate a case as a prosecutor, give the reasons. You, on your file, is there. So why shouldn't we as citizens see it? When we are paying you, look at it.
Okay.
Give your reasons.
Otherwise,
how?
This thing that Godwin had accused or is accusing the previous administration of intentionally persecuting, if we are not careful, it may not be his government, but it may be a cycle that may be repeated. And so if we do not have clear timeline ambits within which this could be done, what it means is that it will be coming every time, state resources would have been used, people who would have intentionally participated would walk free.
Yeah.
Because if you are required to give reasons, and your reasons are justified, what it means is that somebody else has not done his work well.
Yes.
And that person now can be set.
You see, the danger, the danger with the reasoning, and I'll just, the danger with the reasoning is that, look, sometimes, even for effective prosecution, you may even want to use previous accused persons for the purposes of serving as prosecution witnesses. Inherent in it is potential mischief, reward. Because if you know that you can become a potential prosecution witness, there are benefits for you to implicate. It's usually the prisoner's dilemma concept.
Yeah.
That is also inherent.
Good.
And so you want to give an attorney general a few, what shall I say, benefit. Just that at the end, you have the benefit of a trial judge evaluating the evidence, whether it supports that or not.
Yeah.
But to subject the power of withdrawal, the power of nolle prosequi 54 and 59 to judicial scrutiny, I think will be problematic.
Maybe
good. Mr. Counsel, let's read this. Let me also come in. So in the UK, where we've copied a lot of our laws and they are ahead of us, look at the reasons they do it. They say, if the reason for terminating the proceedings is the insufficiency of the evidence provided to the Crown Prosecution Service at the date, this must be made clear to the court and the defendant. This must be made clear. So you see, we say UK, they are miles ahead of us. And they
malicious prosecution.
Yes.
You know the dangers associated with malicious prosecution.
I really appreciate.
No, but you see, you also do not want the republic to be mortared in, what do you call it?
But it will
damage. You also need to be. So
thank you very much.
But the prosecution gets started by, say, a different regime.
Then
another regime comes to pay the cost.
Governance is a continuum.
Thank you very much.
My final word on this. You know, Alex Sebefia, he was a big man in the Crown.
Yes.
One day, bring him here. Let him. He lived it. He was a big man in the Crown prosecution. Let him explain why he do it.
Thank you.
Yo, ebuson for winning and someone about beto. Yepono so because so when you subscribe to channel idea, bomodi say be subscribe. Now fi wa like video, don't give us a thumbs up. Now fi share ma wo foforo so na when you be here na wo hu and someone ekoso e wa Ghana me muharam. Also betimi atchere wadwen afaye and some way nyina ho e wo comment box ni mu. Mo beti minka bi in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.